Good morning. I now call the meeting of the Code Enforcement Special Magistrate to order. Please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Welcome to the Hillsborough County Code Enforcement Special Magistrate hearing. When addressing the magistrate, please state your name, address, and speak clearly into the microphone. If you're planning to speak during this hearing, you must sign the speakers list located at the front door so your case can be called. Any person who decides to appeal a decision of the Code Enforcement Special Magistrate will need a record of the proceedings. The record is comprised of the testimony and evidence upon which an appeal is based. It is your responsibility to ensure that a verbatim record of the proceedings is made. By law, you have 30 days from the date of my order to appeal my decision to circuit court. Presentations by the county, respondents, and opposition must be kept to a maximum of 10 minutes each. The special magistrate may recess at 12:30 and reconvene at 1:30 p.m. to conclude its business if needed. The basic process for this hearing is as follows. Ms. Meyer will conduct the oath of witness, and your case will be announced. Staff will present the evidence on your case, and then you'll be allowed to rebut that evidence and explain what has occurred. We'll close the hearing and announce a decision. I may ask and allow other witness testimony if necessary. Depending on my order, the county staff may later have to conduct an inspection to see if you have complied. If the staff believes you have not complied, you'll receive a notice in the mail. By law, you have 10 days to contest that notice. Otherwise, it will be considered correct and a lien may be filed against your property. For false alarm or water resource cases, if you have not complied by paying the past due burglar false alarm fine or water resources penalty fine within the time ordered, you'll receive a notice in the mail. By law, you have 10 days to contest that notice. Otherwise, it will be considered correct and a lien may be filed against your property. If you have any questions, these rules are outlined by Hillsborough County Codes of Ordinances and Laws, Chapter 14, Article 2, Section 14. And before we begin, please silence all electronic devices. First order of business, I approve the minutes for December 10th, 2021 and January 11th, 2022. Ms. Meyer?
First case is on page 2, number 4, case number WR 2102637. The owners are Luisnes St. Felix and Terra Sadie St. Felix. Location 11449 Sage Canyon Drive. We have service and someone is here for this case. If you're here for this case, come up now. Just one moment, sir. I missed a step.
It's okay. I'll give you a chance.
All the county staff who will testify, including those who are online, need to take the oath of witness. Please stand and raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? And now, sir, would you raise your right hand, sir? Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
And state your name and address.
Luis St. Felix, 11449 Sage Canyon Drive, Riverview, Florida, 33578.
Thank you, and I apologize for messing up your name.
Ain't no problem, it happens.
And is that your property in the photo up there?
Yes, ma'am.
Thank you.
Mr. Pisano?
Good morning. I'm Carmine Pisano with Hillsborough County Code Enforcement. This is the case of WR 2102637. On Friday, 10/8/2021 at 7:38 hours in the morning, Officer Paul Whaley arrived at 11449 Sage Canyon Drive to observe the sprinkler system watering the lawn in the rear of the property. This is a watering day, but during non-watering hours. The notice of violation was mailed on 10/11/2021. On 11/1/2021, an appeal was received at the office. On 11/2/2021, the appeal board met and denied the appeal. A notice was sent to the property owner. Default letter was mailed on 11/17/2021. Notice of hearing was sent out on 12/20/2021. And this fine is $200. There is a prior violation, case WR 2102052 on 7/21/2021. The watering violation resulted in a warning. And on case WR 2102481 on 9/23/2021. A watering violation was incorrectly noticed as another warning. So I stand corrected in the progression of fines. He got a gimme on the 2 warnings where he should have been fined. His fine shouldn't be $100.
For the September incident, he was warned, but he should have been fined.
He should have been fined.
I understand. Okay. So now this is the third.
This is the third, so it's the court's discretion whether you want to give the 100 or 200.
I understand. Okay. Sir, what would you like to tell me?
So when the watering happened, our lawn was just fertilized the day prior, and the technician informed me that we would have to water the lawn within 24 hours of that fertilization. And from my understanding, with the sticker being out in the lawn stating that it was fertilized the day before, my understanding was that we could water the lawn, based on that chemical product that was, applied to the lawn. So I just wanted to confirm whether or not that was a correct statement the technician, the fertilizer provided.
Yep. Mr. Pisano, the date of watering was correct. Time was incorrect. Is
Yes.
that correct?
Correct, sir.
Okay. So there was a correct day to water for you anyway. The trouble is that you watered after the allotted time. So you could still water the fertilizer in. And I mean, it's really great that they came the day before so that it was actually on your watering day anyway. But unfortunately, it was after a period of time which you're allowed to water. That was the reason for the violation.
Okay. And going on the recommendation, I contacted the water department, and they brought out the specialists, and they came out and they did an evaluation of my sprinkler system, and comes to find out I had improper timing sets on the sprinkler. I had improper schedule. So she had to go in and manually correct that for me. And ever since then, we've been following a strict protocol.
Okay. So it's your testimony that you don't anticipate having any issues with your sprinkling system here moving forward.
Correct.
Okay. Well, I understand the confusion, and I think what I'm going to do here, because you came down and had a conversation with me and explained the situation, I'm going to reduce the penalty of your fine from $200 to $100. Understanding that obviously there was a gimme there back in September. So, but please keep in mind moving forward, if this case comes back before me again, then we'll have to move things up a little bit. If that makes sense. Okay.
Yes, sir.
All right. So I'll go ahead and do that for you this time, and I appreciate you coming down and telling us what's going on, and just make sure you keep it within the watering hours and on the correct days. Okay.
You got it. Yes, sir.
All right, sir. Thank you very much.
So do I just be on the lookout for that in the mail?
You'll get it'll come in the mail for you, and you'll have 30 days in which to deal with it.
All right. Thank
Okay.
you, Officer Lorenzo.
Thank you. Appreciate it. I rule in case WR 2102637, the base damage of the violator has failed to pay the water resources penalty fine for illegal sprinkling imposed by section 111-7 Hillsborough County Codes of Ordinances and Laws, Part B, Public Utilities. I revise the penalty amount to $100, and I grant the violator 30 days to pay the water penalty fine imposed. Order of payment is not made by the day, a fine of $20 per day be assessed. Next case, please.
Turn back to page 1. Number 1, case number WR 2102094. The owner is Giovanni R. Nunez, 10558 Laguna Plains Drive. We have service and no one is present.
I am Carmine Pisano with Hillsborough County Code Enforcement. This is the case of WR 2102094. On Friday, 7/30/2021 at 4:39 a.m., Officer Ted Baker arrived at 10558 Laguna Plains Drive to observe the sprinkler system watering the lawn on the left side of the driveway. This is a watering day, but conducted during non-watering hours. A notice of violation was mailed on 10/12/2021. Fault letter was mailed 11/17/2021, and the notice of hearing was mailed out on 12/20/2021. There was a prior violation, WR 2101581 on 6/3/2021. The water violation at that time resulted in a warning. This incident is a fine of $100.
I rule in case WR 2102094 that based on the evidence presented, the violator has failed to pay the water resources penalty fine for illegal sprinkling imposed by section 111-7, Hillsborough County Codes of Ordinances and Laws, Part B, Public Utilities. I grant the violator 30 days to pay the water fine imposed in order if the payment is not made by that date, a fine of $20 per day be assessed.
Number 2, case number WR 2102460. This case complied January 27, 2022. Number 3, case number WR 2102522. This case complied February 3rd, 2022. Page 2, number 5, case number WR 2102659. The owner is Cerberus SFR Holding 2 LLP, location 9630 Sage Creek Drive. We have service and no one is present.
Excuse me. I am Carmine Pisano with Hillsborough County Code Enforcement. This incident is case number WR 2102637. On Friday, 10/8/2021 at 7:38 hours, Officer Paul Whaley arrived at 11449 Sage
Mr.
Canyon.
Pisano, sorry to interrupt you. We're on the case number 5.
Oh,
We just ruled on that one.
sorry,
That's okay. Didn't want to get you through the whole thing and then
2659. Take a mulligan on that, all right?
that's your mulligan.
Okay.
I think the PowerPoint was correct.
Yeah, I had the right PowerPoint.
Yep.
Reading the wrong testimony.
Correct.
Try again. I am Carmine Pisano with Hillsborough County Code Enforcement. This is case WR 2102659. On Wednesday, 10/6/2021 at 7:14 hours, Officer Ted Baker arrived at 7630 Sage Creek Drive to observe the sprinkler system watering the area in the rear of the property. This is a non-watering day during non-watering hours. Notice of violation was mailed on 10/13/2021. The fault letter was mailed on 11/17/2021. Notice of hearing was sent out on 12/20/2021. There's a prior violation on W021000430 on 3/17/2021. The watering violation resulted in a warning. There was a subsequent incident from this hearing on 4/16/2021. A watering violation resulted in $100 fine, which was paid, and this fine is for $200.
I rule in case WR 2102659 that based on the evidence presented, the violator has failed to pay the water resources penalty fine for illegal sprinkling imposed by section 111-7, Hillsborough County Codes of Ordinances and Laws, Part B, Public Utilities. I grant the violator 30 days to pay the water penalty fine imposed. Order if that payment is not made by that date, a fine of $25 per day be assessed. Next case, please.
Number 6, case number WR 2102662. The owners are Jose Luis Munoz and Mariko Munoz. Location 10027 Ivory Drive. We have service and no one is present.
I am Carmine Pisano with Hillsborough County Code Enforcement. This is the case of WR 2102662. On Wednesday, 10/6/2021 at 7:28 hours, Officer Ted Baker arrived at 10027 Ivory Drive to observe watering in the area of the rear of the home. This is a non-watering day during non-watering hours. Notice of violation was mailed on 10/13/2021. The fault was mailed on 11/17/2021. The notice of hearing was posted by Officer Baker on 1/18/2021. There's a prior violation, WR 2100438 on 3/17/2021. Ordering violation resulted in a warning. There was another incident, WR 2102430, and the ordering violation in that case resulted in a $100 fine. This is a $200 fine.
I rule in case WR 2102662, the based on the evidence presented, the violators failed to pay the water resources penalty fine for illegal sprinkling imposed by section 111-7, Hillsborough County Codes of Ordinances and Laws, Part B, Public Utilities. And grant the violator 30 days to pay the water penalty fine imposed. Order, if the payment is not made by that date, a fine of $25 per day be assessed. Next case, please.
Page 3, number 7, WR 2102684. The owner is FKH SFR C1 LP, location 9835 Ivory Drive. We have service and no one is present.
I am Carmine Pisano with Hillsborough County Code Enforcement. This is the case of WR 2102684. On Friday, 10/8/2021 at 5:11 hours, Officer Ted Baker arrived at 935 Ivory Drive to observe the sprinkler system watering the area in the rear of the home. This is a non-watering day during non-watering hours. Notice of violation was mailed on 10/15/2021. Default letter was mailed out on 11/17/2021, and the notice of hearing was sent out on 12/20/2021. Prior violation of WR 2102544 occurred on 9/24/2021. Ordering violation resulted in a warning. After the incident being heard today, there was a ordering violation, WR 2102889 on 11/10/2021. That ordering violation resulted in a $200 fine. This incident is a prior case to that. It is a $100 fine.
I rule in case WR 2102684, that based on the evidence presented, the violator has failed to pay the water resources penalty fine for illegal sprinkling imposed by section 111-7, Hillsborough County Codes of Ordinances and Laws, Part B, Public Utilities. Grant the violator 30 days to pay the water penalty fine imposed. Order, if payment is not made by that date, a fine of $20 per day be assessed.
That concludes the water resources cases.
Excellent. Next case, please.
Turn to page 4, under landscaping and natural resource cases. Number 8, case number L 216527. The owner is Paul F. Savage Real Estate LLC. The location is a vacant commercial property at South Highway 41 in Ruskin. We have service and we have a party online to testify. Good morning, ma'am. Could you raise your right hand, please? Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? I can't.
I think you're muted.
I do.
Okay, thank you. And state your name and address.
My name is Gaylyn Love, and I live at 2807 Gulf City Road in Ruskin, Florida.
And what is your relation to this case?
I'm just a resident in the area.
Okay. Thank you.
Thank you. Did you want me to?
One moment, please.
Okay.
Good morning, Ms. Hall.
Good morning. This is Krista Hall with the Development Services Department. This is case L 216527. Property owner and violator is Paul Savage Real Estate LLC. Violation address is US 41 Highway, Ruskin. Violation, unpermitted disposal of fill materials within the 100-year floodplain that alters the flow of surface waters in the area. Ordinance violated is section 4.01.03, first inspection, January 21st, 2021. First notice, January 29th, 2021. Last inspection, January 26, 2022. 4 inspections, actually probably more. This map was provided to us by the floodplain coordinator, Mr. Dahlman. Identifies that the area and the property is in the floodplain. I have Abdel Lorfi who is a PE with the county stormwater engineering team. Can you identify this map, sir?
The other one, do the other one.
Okay, this is the FEMA map.
Yeah, there's another map.
Let me go to the next page.
Yeah, okay. This is Abdel Arfi, Stormwater, Hillsborough County. The subject property lies within the new coastal FEMA, and there's a new elevation for that site. And we encourage the engineer of record for the site to contact Kyle Dolman to get more information on the standard of the construction for that area, as FEMA has a new requirement for construction within the new coastal FEMA. So the entire property lies with that. I think the elevation is 10, but they need to contact Kyle Dolman. There is also maybe a riverine flooding due to the county model, and that will be compensated for. And also they need to contact us for a stormwater requirement for that site as well.
Thank you, sir.
So just, I'm sorry to interrupt, just to confirm, so the entire property is in the floodplain
Yes, sir. The entire property is within the new coastal FEMA.
and it's currently undeveloped?
It appears to be.
Okay, thank you.
The next picture will identify the inspector's investigation. On January 21st, 2022, John Beavers went to the property and he identified mulch had been disposed on the property. Mr. Beavers is available. Could you explain this picture, please?
Good morning, John.
Morning. Yeah, this is looking east towards the Little Manatee River. There is between 2.5 and 3.5 feet of organic material of mulch that was disposed of across the property.
I know I said good morning, John, but you probably need to identify yourself for the recording ladies downtown just for that testimony, please.
John, you're muted.
John Beavers, Environmental Investigations Supervisor for the Natural Resources Team.
Thank you.
This is a current picture taken on the 26th, and it is looking north. A year later or so the material is is propagating a lot of weeds. There hasn't been any activity on the site, so it remains pretty much in the same state it was a year ago.
John, has the mulch been removed at all?
There's no evidence of any mulch being removed at all, no.
Okay, thank you, sir.
Similar picture than the first one. This is looking east, and past those two palm trees is a row of red mangroves, and on the other side of it is the Little Manatee River. So it is in very close proximity to the river itself. And this is just hard to see, but it's just a regrowth occurring on top of the unaltered mulch bed.
The county's recommendation for case L216527 is that the property owner submit a compliant natural resources permit application to address the disposed fill materials and to address the stormwater requirements for the property within 30 calendar days. Following items must be included in the application. They must submit a professional engineer's plan and calculations as necessary. Provide an as-built of the final grade elevations, which includes an elevation certificate. Obtain and finalize the natural resources permit after receipt of application within 90 calendar days, or remove all fill materials from the property within 30 calendar days. We are requesting that high fines be applied for failure to meet these timeframes due to the fact that he is a repeat violator. He was noticed as a repeat violator. Past case was identified as CE 174330.
All right, so we're citing the owner as a repeat violator?
Yes, sir.
And just to confirm, John, this is fill, this isn't even fill material to build anything on. This is merely just disposal of yard materials or waste on a lot and spread, and nothing's been done?
That's correct. It looked like a stockpile of shredded trees from various sites, either in this county or other counties, and just brought in and
Dumped.
disposed of. Yes, sir.
Okay, and have we had any contact with the owner? Or the LLC for which is being cited?
I haven't personally. I think Krista can answer that question better.
I received a call several weeks ago from Mr. Savage, wanting to know why he got cited. And he said that he had a permit for this, and I asked him to bring that forward, and I have not heard from him since.
Okay. Okay.
Ms. Love?
Mrs. Love, what would you like to tell us? You're muted, ma'am. That's okay. I read lips pretty good, but
I'm sorry, can you hear me now?
I can. Yes, ma'am.
Okay, I apologize. I just really briefly, I wanted to say that during the early part of January, I witnessed multiple semi-truckloads dumping mulch onto the subject property. So I decided to report it in the hopes to suspend the activity so that the adjoining properties and neighbors wouldn't have to endure what my family has the past 6 years. 6 years ago, Mr. Savage hauled in hundreds of loads of unpermitted fill to the lowland property that he owns adjoining my homestead. And those actions have resulted in repeated flooding of my property, which to date hasn't been resolved. So that's all I have to say. Thank you for your time.
Thank you. Ms. Hull, just to follow up. Yeah, thanks. Does the deposit of this fill, does it impact the watershed of the property, especially with it being near the water?
The engineer identified that it's in the flood zone area,
Okay.
and that identifies that it can impact adjacent properties because he's raised the property without county permits to compensate any flooding impacts.
Okay. All right. Thank you. Okay. I think I understand. Thank you for the testimony, Mrs. Love. I rule in case L 216527 that based on the evidence presented, I find the property is in violation of Hillsborough County codes or ordinances listed in staff's presentation. Further, based on the gravity of the violation, the actions taken by the violator and the violator's history, I concur with staff's recommendations. Require the property owner to submit a compliant natural resources permit application to address the disposed fill materials and stormwater requirements for the property within 30 calendar days. Following items must be included in the application. To submit a professional engineer's plan and calculations as necessary, and provide an as-built plan of the final grade elevations, which includes an elevation certificate. Then to obtain and finalize a natural resources permit after receipt of application within 90 calendar days, or removal of all fill materials from the property within 30 calendar days. Failure to meet any of the timelines listed above will result in a penalty of $5,000 per day. As a repeat violator, this fine is $5,000 per day.
Thank you, sir.
Thank you. Next case, please.
Turn to page 6, number 13, case number L 216899. The owners are Michael, Hannah, and Mary Hager. The location is 18419 Swan Lake Drive. We have service, and the owners are present. Would you raise your right hand, please? And if she's going to testify also. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Say it out loud, please.
I do.
Okay. Thanks. And both of you state your name and address.
My name is Michael Hanna. The address is 18.
Pull
Mike.
it down. Pull it down.
Yeah, the last guy was really tall. My name is Michael Hanna. The address I reside at is 18419 Swan Lake Drive in Lutz.
Mary Hager, the address is 18419 Swan Lake Drive, Lutz.
Thank you.
Thank you. Go ahead, Ms. Hall.
Okay, this is case L216899. Wayne Doyen is the inspector, and he'll proceed with the case.
Good morning, Wayne Doyen, Hillsborough County Natural Resources. Case L 216899, owner violator Michael Hanna, Mary Hager. Violation address 18419 Swan Lake Drive, Lutz. Violation observed, unpermitted removal of a 37-inch DBH laurel oak tree. Ordinance violated, section 4.01.03. First inspection, April 19, 2021. First notice, May 26, 2021. Last inspection, January 19, 2022. Inspections conducted 4.
Okay, why aren't you moving? There we go.
On May 26, 2021, I arrived for a complaint for unpermitted effective removal of a 37-inch DBH laurel oak tree. Due to the topping of this tree, there was a violation for effective removal. The tree was not going to survive. My recheck on January 25th, 2022 shows what I determined on that first inspection. There was also no new plantings. During this case, I have tried exhaustively to find the tree company that was responsible for this actions. 2 men and a chainsaw. I attempted to hand deliver mailings of notice of violations, which were all unsuccessful to these 4 different locations. I did everything possible that to try to help these homeowners, but we could not track down this company. Case L2166899, staff recommendations. Plan to donate 37 inches DBH of approved shade restoration trees, or contribute 37 inches to the restoration fund, or a combination of plantings and contribution to the fund within 60 days. Trees must be 1-inch DBH or larger, minimum 8 feet in height. Florida number 1, chosen from the Hillsborough County approved tree list as appropriate. The property owners, Michael Hanna and Mary Hager, will be responsible for this violation. Contribution to the fund equates to $65 per DBH inch. Fines will be issued for failure to meet timeframes.
Okay, folks, good morning. What would you like to tell me?
Good morning. Yes, the property in question had 3 laurel oaks that were planted. Sorry, am I loud enough to? Okay. 3 laurel oaks that looked planted about the same time the property was built in the 70s. At this time, they've reached the end of their natural lifespan, about 45 years. We engaged a tree specialist to remove them, to start with the 2 in the rear of the property, and he applied for the permits. Came along, did some work on the one on the front, and then unfortunately disappeared on me. I then hired 2 men and a chainsaw who came, checked the permits, removed the 2 trees in the rear, which had been apparently we got a permit for, and the one in the front, they came back later and trimmed it down because it is still fairly lively, as it were. It still had life in it. We've still had that. We've had that since checked by an arborist, and he says it's probably going to be good for another couple of years as it is, but ultimately it will have to come down. Our concern is that we don't understand why the permit didn't cover all of the trees, as they were all laurel oaks at the end of their natural lifespan. The one at the front was particularly dangerous. It was dropping branches. Right before we bought the property in 2019, the roof had to be replaced because of one branch going through that. And it was overhanging the road. the neighbours and dropping branches there. So something had to be done about it. Mr. Doyen, we've been dealing with back and forth on this issue, and he himself said that was dangerous. So that tree needed to be removed or certainly made safe, and I believe we've done that for the moment. We do have plans longer term to remove the tree completely because, again, it's dying. And it will be at a state where it'll have to come down within a year. I think 2 years, the arborist said. But we haven't gone ahead with that, obviously, because we're waiting to resolve this issue at the moment. We have also planted other trees, and we did send that information to Mr. Doyen. I don't know why it's listed there that we haven't. We have gone ahead with that. We have got other trees that we have on the property. I don't think they're what you call the shade trees, but you know, we're happy to have the shade up there because, you know, it's Florida, it's hot, and as a Brit, I'm not appreciating that. We've done everything we can to follow the rules here, and it appears, but because the tree guys who are the experts here maybe haven't followed the rules, or there's been some sort of administrative mishap where we should have had permits for all of the trees, we're paying the price, and I think the fine was like $2,500, which is pretty much the budget to be doing the front yard and getting rid of the tree that's there that was dangerous. We're appealing it because, you know, it was dangerous. It should have come down, and I really don't know where we go from here. I mean, I think we've done everything we possibly can to make it safe. I don't want one of my neighbours getting hit by a branch or worse still, their dog. You know,
You mentioned that you've spoken with an arborist. Do you have an arborist report of something that's?
It's actually not a report, but he did give us the quote to take the whole thing down. So, and part of why the 2 Men and a Chainsaw guy said he didn't take the whole thing down was our front yard is very small, and the whole tree kind of is like the middle of the yard. So when he took the ones down in the back, the lady had filled the trunks with concrete, and it was just impossible to get them down. And now they're like creating these big craters where the roots are dying off inside. So, and Travis said he wasn't equipped to try and get all of the roots out of the front. So we had to get what was dangerous and, you know, overhanging things down, and then find somebody who could do that. Now, this guy, Mark Hughes, says he can do that, and he gave us a quote for $2,800 to take what's left down and to fix the whole front yard so it doesn't collapse in the front yard.
Yeah, I understand. I understand the quote to do the work. I'm just looking for something that says that you went to the arborist and had a conversation in regards to the livelihood of the tree. Some kind of report that says that tree was, you know, needed to come down.
This is for grinding the stump and for actually doing the whole removal.
Right. So Ms. Hall, you might be able to answer the question to them in regards to a permitting issue, but my understanding is that, at least from your testimony and her testimony, that the permit was for the back trees and not for the front tree, correct?
I believe so, and I think it should have been for all three. In fact, Mr. Doyen sent me an email and says that the tree, and I've got the email here, the quote is, the tree will have to be removed because it's non-viable and hazardous. So I think the permit should have been for the one at the front as well.
Well, the reason it's, Mr. Doyen might want to chime in here, but at least from his testimony, it sounded like the reason he wrote that email with that language in it is because of the condition of the tree now without having the shade canopy. It's been scalped.
Right.
So
it was like that before.
The very first time, he said he remembered my house and he remembered the tree in the front, and he thought it was bad at the time. So if he issued the permits for the two in the back,
I need you to speak into the microphone, please.
yeah, ma'am. Hold 1 second. Go ahead and say that into the microphone clearly for my ladies downtown, if you would, please.
I'm sorry. When he first arrived at the house, the very first time, he said he remembered the house and he remembered the tree in the front, and at the time it was bad, and that he had only issued the permits for the ones in the back. It was the tree company.
Well, I don't think Mr. Doyen issues the permits, but go ahead, Mr. Doyen. You want to respond?
The two trees that were permitted for removal in the back were the trees that were permitted at the time. The front tree was never a question at the time.
Okay.
So,
okay.
I mean, the front tree was as old and was dropping branches and was dangerous as well. It was in the same condition.
I understand, but without some sort of paperwork from an arborist saying that the tree, in order to get around not having a permit and being able to cut it down on your own, you'd need a certified arborist to say that tree needed to come down. You don't have any reporting that says that, correct?
No, and we don't have a permit. We had no way to check the permit.
No.
We got a permit to take the trees out, so we didn't.
Please
I
speak
understand.
into the microphone.
We left that to the tree guys.
Excuse me,
We
please,
relied on them.
please continue to get closer to the microphone. They're
I'm
having trouble
sorry.
getting you downtown.
I'm sorry. I was just interrupting, actually. It's okay.
No problem.
Yeah, we were very much relying on the experts, the tree guys to do it.
Understand.
And, you know, I didn't realize that we didn't have a permit.
I understand.
I mean, had we realized that, we'd have got one. I'm pretty certain that they're dropping branches everywhere, that it would have been approved. I mean, it was the same age as the other trees. We've had laurel oaks in that street where last week were being taken down and trimmed because they're at that age. The whole street's at that age where they planted all laurel oaks at the time.
Understand. Okay.
And we just want to make it safe. We want to do it right. And I apologize. We didn't realize there wasn't a permit. We did leave that to the tree guys, and we maybe should have checked up on that, and we didn't.
And if we're going to spend $2,500, we'd like to be able to finish taking out what's there and fix the front yard at the same time.
And replace it with more trees.
Well,
Yeah.
okay, I
Because-
can answer one question. You don't need a permit right now to remove this tree. We're finding it in violation. And when it's in violation as effective removal, you can remove the tree without a permit. What you'll have to do though is do full replacements, and the value of this tree, if you pay into the restoration fund, is $2,405. Or you can plant trees on your property for credit. And let me go to the recommendation. And that was 37 inches.
Yes, given the size of our property, can we really get 37 inches of trees planted in that front yard?
That's the trouble. It's
Okay.
37
I mean,
inches of.
And there's a-
Realistically.
As-
And we did buy a shade tree immediately when Mr. Doyle told me in the summertime that there was no shade tree left on our property and that one didn't count anymore because it was bad. So, I mean, I immediately went out and I sent him the receipt and I said, is this the right tree? I sent him a picture of what I was buying. He said, yes, it was fine. And when they came and planted it, it started to die. The nursery did. It was a licensed nursery. We talked about it. I mean, we have emails back and forth. We've had a lot of communication about that. So I'm trying to get a tree, but the only other place to plant a tree in the front yard literally is where this one is. So it's like, it's just really frustrating because we're trying to make it better. And
Okay,
I understand. Let us give you some more clarification on that, because you can plant your credit for that tree. You can plant anywhere on your property. It doesn't have to be in the exact same spot in the front yard. So you could get credit for trees planted if you planted them in the backyard, in the side yard, anywhere on your property.
yes, yes, ma'am. And you can do a combination. If you
Ma'am?
can't get 37 inches, and at this time, we're doing double credit. So that would really, for every inch, you're going to get 2-inch credit. So if you plant, let me get my math in my head right now.
18 and a half?
18, yeah, that sounds like
18 and a half?
18 and a half inches of trees. That's like 9 trees at 2-inch diameter. If you do that, you get double credit. If you can't put all 9 trees, we can do a combination where you plant some trees, get credit for that, and then the balance you can pay into the fund. So you can do a combination. That's what the recommendation has.
Would that include new laurel oaks going in on our property?
You can put laurel oaks.
Because
but
we
there's
have some
another-
already out the back growing.
But you can put other shade trees that's on the list that was provided in the letter.
I don't know who's going to go in my swamp and measure the tree, but
So or you can donate trees to the county. We try to get back something to your property, some shade value back onto your property. So if you don't want to put 9 trees, you can do a couple and then donate the rest to a county park. We have a park
Or
program
school.
that takes trees.
Or
Or
schools?
Yes, we have county schools that can take trees.
no, I understand, but 37 inches of 18 and a half inches of trees at their size now is going to be too much trees for the property. It's not that big.
I understand that you've also had a tree company involved, and the tree company has disappeared. And I know Mr. Doyle's gone to great lengths to try to find them, to hold them accountable for this for you as well, to share in the burden of this. So I'm willing to take that into consideration too as a part of my ruling to try to help with that too. So I understand ultimately at the end of the day, the property owner is responsible, and I understand that, but it seems like you've gone above and beyond to try to do the right thing from the beginning. So I'll help with that too in my ruling and my recommendation. Okay. And I'll give you some extra time to do it as well. So, because I know you've got a monstrosity in the front yard that you need to get rid of. So I'll help with that too. Okay.
Thank you.
Thank you.
All right. No problem. Thank you. I rule in case number L216899. The basis of the evidence presented, I find the property is in violation of Hillsborough County Codes of Ordinances as listed in staff's presentation. Further, based on the gravity of the violation, the action taken by the violator and the violator's history, I review with staff recommendations, and I require the homeowner to plant or donate 30 inches DBH of approved shade restoration trees or contribute 30 inches to the restoration fund or a combination of plantings and contribution to the fund within 90 calendar days. Trees must be 1 inch DBH or larger, a minimum of 8 feet in height, Florida grade 1, chosen from the Hillsborough County approved tree list as appropriate. Property owners Michael Hanna and Mary Hager will be responsible for this violation. Contribution to the fund equates to $65 per DBH inch. Failure to meet any of the timelines listed above will result in a daily fine of $150 per day.
Okay.
All right, folks.
Thank
I gave you
very
some
much.
extra time. Okay.
Thank you. Have a good day.
Thank you very much. Next case, please.
Turn to page 7, number 14, case number L216938. The owner is Beverly J. Coleman, 7738 Carriage Point Drive. We have service, and we have someone signed in for this case. Good morning. Raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
And state your name and address.
Omisiman Coleman, 7738 Carriage Point Drive, Gibsonton, Florida, 33534.
And what is your relation to this case or to the owner?
Also an owner. This is my wife.
Okay.
Yeah, sorry.
Okay, well.
That qualifies.
Your name was not on the agenda. Yes, okay, thank you.
Thank you. Ms. Hall?
Morning. This is case L216938. Property owner and violator is Beverly Coleman. Violation address 7738 Carriage Point Drive, Gibsonton. Violation observed. The required street tree is deficient per the Land Development Code for Carriage Point subdivision. Ordinance violated section 6.06.03. First inspection June 11th, 2021. First notice September 18th, 2021. Last inspection January 24th, 2022. 2 inspections conducted. The photos were taken by John Beavers. Since he's available, please explain the photos.
John Beers, Environmental Investigation Supervisor with the Natural Resources Unit of Development Services. The street tree is on the right, the front yard lot tree is on the left. They're both basically about the same age. And as you can see, the street tree has been topped, hat racked, effectively removed. There's a faint circle there, but that's basically what's left of the tree. This picture was taken on January 24th, 2022, and the tree is trying to recover with epicormal sprouting. However, it remains and will be in a hazardous condition in the future, and there's been no restorative plantings of that tree or that tree.
Staff recommendation for L216938 is that the property owner is to plant 1 county-approved street tree within 45 calendar days for Carriage Point subdivision. Trees must be 1 inch DBH or larger, 6 feet in height minimum, and a Florida grade number 1 nursery chosen from Hillsborough County approved street tree list. Palm trees may be 8 feet in trunk height at a ratio of 2 to 1 shade tree. Fines will be issued for failure to meet the timeframes. The street tree is supposed to shade both the sidewalk and the street, and unfortunately, when you top it like that, it does not qualify any longer as a shade street tree. And it's also can be hazardous in regards to those epicormal sprouts. It can be a problem for the county road and the county sidewalk. So unfortunately, you'll need to replace that street tree.
Okay, sir, go ahead. What would you like to tell us?
I understand, being a first time homeowner, didn't know, first of all, second of, it was dropping so much, I don't know what to call it, pollen or whatever it is. It had me and my daughter basically held captive in the home because we couldn't come out due to allergies. We were just sneezing all over the place and just horrible. So I didn't know. I just went out and oh, that looks nice because my neighbor's tree is like that. And that neighbor's tree is like that. And this neighbor's tree is like that. So I'm like, well, what can I?
But you know what I'm going to say in regards to your neighbor trees, right?
I don't know, but I do understand that.
Absolutely. Now, if you wanted to, if you're not fans of your neighbors and they're not inviting you to Thanksgiving and you want to, file some complaints on them, you can, but I can't take that into consideration in this particular case. So
I'm not using them as.
I understand.
I'm just using them as a reference, actually, to me saying, "Oh, I guess." I didn't.
I understand.
Problem.
Mm-hmm.
Until I reset. What did I do wrong?
Yeah.
So.
The good news is, as replacement of this street tree, you're able to choose the shade tree that you replace with. So
That's
obviously,
fine.
you can pick something that might be a little easier on the allergies.
Yes, sir. Yes, sir.
As part of this process,
Yeah.
though, understand that you didn't know, but that doesn't make you not at fault, unfortunately. So
Absolutely.
do you think that you can have that accomplished within 45 days, or any concerns about the timeline?
If you can give me a little time, I'm more than happy to. Because when I do walk by, I'm like, man, I cut my tree, and I didn't really want to do that.
I understand.
And I don't like the looks of it, of course, and I would like to replace it. And if I could get a little extra time,
All right.
no problem.
Ms. Hall, do you have any concerns with adjusting the timeline?
No, sir. The time frame would hit a good time for the spring season, and hopefully you can find a good, healthy tree for
Right.
that street.
Okay. Yeah.
All right.
Yeah.
How about 60 days? Is 60 days
That's
work for you?
fine. That's fine. If I need any longer, who should I contact?
You're going to be in contact with the folks of Natural Resources when you'll get a notice in the mail based on the findings of this hearing, which gives you contact information, and you can be in touch. And then obviously they're going to come out and inspect in 60 days to make sure that that's been completed.
Sounds good.
Okay.
Sounds good. Yep.
All right, sir. Thank you for coming down. I appreciate you taking the time.
Yep.
I rule in case L 216938, the basis of the evidence presented, I find the property is in violation of Hillsborough County Codes of Ordinances listed in staff's presentation. Further, based on the gravity of the violation, the actions taken by the violator and the violator's history, concur with staff's recommendations, require the homeowner to plant one county-approved street tree within 60 calendar days for Carriage Point subdivision. Tree must be 1 inch DBH or larger, 6 feet in height minimum, and Florida grade 1, chosen from the Hillsborough County approved street tree list. Palm trees must be 8 feet height and trunk height and a ratio of 2 to 1 shade tree. Fail to meet the timeline of 60 days listed above will result in a daily fine of $125 per day. You're all set. Thank you, sir. Next case, please.
Page 8, number 17, case number L 217056. The owner is Ryan P. Prawley and Jennifer Prawley, 13506 Tufts Place. We have service, and we have someone here. Good morning. Raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
And state your name and address.
Ryan Proley, 13506, Tufts Place, Tampa, 33626.
Thank you.
Go ahead, Ms. Hull.
Case L 217056. Property owner and violator is Ryan Prawley and Jennifer Prawley. Violation address is 13506 Tufts Place, Tampa. Violation observed, unpermitted removal of a 16-inch DBH water oak tree. Ordinance violated is section 4.01. First inspection, August 3rd, 2021. First notice, August 10th, 2021. Last inspection, January 24th, 2022. 3 inspections conducted. The inspector was Wayne Doyen. Wayne, please proceed with this.
Wayne Doyen, Hillsborough County Natural Resources. I arrived at this address on August 3rd, 2021. by a complaint for unpermitted removal of a 16-inch DBH water oak tree. I spoke to the owner's father at that time, identified the reasons that he didn't have a permit. I asked if they had a certified arborist report. They did not. So this is where we're at as of August 3rd, 2021. Next slide. January 24, 2022, reinspection property with no new plantings. I have been in contact with Mr. Brawley, and he did say he's going to take care of the violation. He's been trying to work out with nurseries to get the trees. I'll let him speak from now. Staff recommendation, plan to donate 16 inches DBH of approved shade restoration trees or contribute 16 inches of restoration fund or a combination of plantings and contribution to the fund within 60 days. Trees must be 1 inch DBH or larger, minimum 8 feet in height, Florida grade number 1. Chosen from the Hillsborough County approved tree list as appropriate. Contribution to the fund equates $65 per DBH inch. Fines will be issued for failure to meet timeframes.
Go ahead, sir. What would you like to tell me?
Hey, how are you?
I'm fine, thank you.
Good. So we did take down this tree. We had contacted a couple of tree companies, gotten prices for it. My wife and I are both school teachers. Bound to be about $1,000 to take down the tree. My father-in-law came into town. He's like, I can take care of this. And they're like, all right, great. No problem. Understanding that knowledge of not knowing we needed a permit to take down the tree is no excuse. But that's where we were at. Mr. Doyon came out. He was very nice, explained to us the problem with the tree and that we didn't have the permit to take the tree down. Told us that if we'd called the county and he had come out to inspect the tree, whether or not to approve the permit, that he would have approved the permit. The tree was dying. It was doing damage to the side of our house. It was just not a good looking tree. And it was something that in our opinion, needed to come down. That's kind of where we're at. I had we'd been in contact with Mr. Doyen, and we're going to donate 3 trees to the county, purchase 4 trees, 1 to put on our property, 3 to donate to the county. Got it all set, contacted, I believe, Mr. Dickerson with the county parks department or whoever it is that does that to see where we could have the trees delivered to. He said, okay, great. Here's where you can deliver the trees. And then he's like, oh, but just make sure this isn't the tree. The tree that we had ordered was a Yaupon holly. He said, okay, we accept those trees. When we said, where can we do it? He's just, okay, we'll make sure that it's not the weeping variety of the Yaupon holly. Unfortunately, the ones that we did purchase were the weeping variety. So were $800 in trees that we were going to donate now are no good to anybody. We were able to return those trees to the nursery, not for a full refund. We got about half of our money back. And that's the point where we're at right now.
Okay. I'll add my shameless plug since you said both of you folks are teachers. You can also donate trees to the school district too. So just for your reference for the future. Not that you plan on doing it again without getting a permit. So.
For sure.
Okay. I know you're going through the process and started the process and now you're taking a step backwards. Any concerns with the timeline and getting that completed?
No, I just, the way our house is structured is nowhere good. We're on a conservation lot in the back. There's not a whole lot of room in the front to put that much tree. And with the damage it was doing to the side of our house, so we don't want to put trees in the middle of our yard, but we don't want to put them that close to our house either.
Well, it's good to be planning for the future.
Yeah. Sure. So now we got to take care of a damaged roof and all the other things that were caused by the dying tree. So,
okay.
If there is a fine we can pay, and, again, we're teachers and it just I think it was $1,000, about $1,000 fine for taking that tree down. If there's anything we can do to reduce that and just be done with the whole situation, that would be amazing.
Understand. Mr. Doyen, was it your testimony to the homeowner that there would have been a permit in this case for this particular tree?
I would have, yes, I would have definitely permitted the tree if they went through the proper steps of getting the permit. Because the tree was there at the time it was cut up. I observed a lot of decay in the tree, but it was still alive. So it does require a permit.
Understand. Okay.
Sir, also, I have pictures of the tree down. I have pictures of the damage to the side of the house. I have, I did a little research on how close oak trees should be to the side of the house. And what it told me was at least 15 feet. I have measurements that was only 11 feet away from the house. So that's.
Okay.
I will let you know that the restoration cost for that tree would be $1,040.
Okay. Okay.
That's about, yeah, I think that's what it was.
Okay. I don't know. I'm feeling big in my heart today because I understand that probably would have been something that would have been taken down. Obviously, you didn't understand the process.
And that's no excuse. I understand that ignorance of the law is no excuse for
right
for what's
Absolutely.
actually true. But
absolutely, I'll take a couple inches off just to help out with that process, just because you didn't know and you went through the process. You've been communicating with the staff and the team and trying to do the right thing in the replanting and understanding the constraints of the home. I'm going to do 12 inches.
Okay.
I don't know if that allows you to keep everything on your property or not. You might still have to do some off property, but
now
understand the process going forward and the
believe,
knowledge that you've gained today that you can share with others to keep others from making the same mistake. So I appreciate that too.
Absolutely. Now, I believe there was double credit. So does that mean if we were to replace the tree, we would need 6 inches DBH?
Yes, if you plant the trees on your property or donate the trees, you will get double credit.
Okay.
Is there a timeline associated with that?
But the timeline shown on here is 60 days. Or
Okay.
if you want to change that.
No, I'm just asking, does the double credit, I didn't, is that something that is outstanding, time sensitive or not?
Well, once you said it today, that will stay.
Okay.
Okay.
Terrific. That was the answer to my question I was looking for.
All right. Thank you.
Okay. Anything else you'd like to add to your testimony?
No, sir.
All right. Thank you very much. I appreciate you coming down.
Thank you.
I rule in case L 217056 that based on the evidence presented, I find the property is in violation of Hillsborough County codes or ordinances listed in staff's presentation. Further, based on the gravity of the violation, the actions taken by the violator and the violator's history, concur with staff's recommendations, require the homeowner to plant or donate 12 inches DBH of approved shade or restoration trees, or contribute 12 inches to the restoration fund, or combination of plantings and contribution to the fund within 60 calendar days. Trees must be 1 inch DBH or larger, a minimum of 8 feet in height, Florida grade 1, chosen from the Hillsborough County approved tree list as appropriate. Contribution to the fund equates to $65 per DBH inch. Fines will be issued for failure to meet these timelines of a daily fine of $150 per day. Excellent. Thank you, sir. Appreciate the time. Next case, please.
Page 9, number 18, case number L 217057. The owner is Raina M. Roshan, 17510 Drake Court. We have service. Good morning. Could you raise your right hand, please? Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I swear.
Okay, I need you to get closer to the microphone.
Yes, I swear.
Okay, and state your name and address.
My name is Raina Marie Rochon, and I live at 17510 Drake Court, Lutz, Florida, 33559.
Okay, thank you.
Ms. Hall? Microphone.
This is case L 217057.
Hello, Wayne Dorian, Hillsborough County Natural Resources, case L 217057. Owner violator Raina M. Rashan. Violation address 17510 Drake Court, Lutz, Florida. Violation observed unpermitted tree removal of 2 oaks and 1 pine tree for a total of 57 inches DBH. Ordinance violated section 4.01. First inspection August 3rd, 2021. First notice September 13, 2021. Last inspection January 19, 2022. 3 inspections conducted. Responded to a complaint for unpermitted tree removals on August 3rd, 2021. I have visual evidence of 3 trees that were removed. My recheck of the property on January 19, 2022 shows no new plantings. This is also a case for a different one of my tree services that I cannot find. He's had multiple cases. This company's went after elderly, played on their heartstrings for House Bill 1159. We're still trying to find this tree service, Willie's Tree Service in Halling. I attempted hand delivery mailing notice for violations unsuccessful. Staff recommendation, plan donate 57 inches DBH of approved shade restoration trees or contribute 57 inches to the restoration fund or combination of plantings contribution to the fund within 60 days. Trees must be 1 inch DBH or larger, minimum of 8 feet in height, Florida grade number 1, chosen from the Hillsborough County approved tree list as appropriate. Contribution to the fund equates $65 per DBH inch. Property owner Raina Rashawn will be responsible for this violation, and fines will be issued for failure to meet timeframes.
Okay, ma'am, what would you like to tell me?
First, I'm newer to Florida, so I'm just gonna say I was unaware that we had like some kind of a tree police department or something where that you needed to get a permit from to cut a tree down. Second, I did look at multiple services, and the Willie Tree Services, they do work in my neighborhood. And so I kind of seen their work, you know, they've cut down trees and other things, and they do a pretty good job. So when he broached me about my trees, and he broached me more than once, so he's been doing work in my yard, in my neighborhood for at least a year. I felt comfortable going there because I'd seen his work, and he did good tree work. He did provide me with a card which says he was licensed and bonded. I had his telephone number. This is still an active telephone number. He did call me just like 2 weeks ago to see if I wanted additional tree service. So I know it's still an active number. And I did provide this also to our tree department to look. That's all the information I had, which was on this card, and it does says that he's a licensed and bonded company. Honestly, when I did reach out to other companies also. No one really mentioned all the steps to me that were required in Florida for tree removal on properties that require permits or anything. So I just wasn't aware that that was something I was supposed to look for with a tree company. Usually they handle that stuff, part of it. So I just didn't know that was going on. And for the trees that were removed, one especially was pretty much dead. I think there was like one limb that still had some green on it. And it was so bad that it caused damage to my car. Literally about 3 days prior to being removed, it was already set up. And I have the car information that even talks about that, it had to have like tree sap and things removed from my car and the amount of damage. That's how bad the tree was. When the inspector did come, I kind of explained the situation. He told me those were trees that probably would have been permitted to have been removed. The one with the tree damage to my car was very close, or probably 10 or so feet. I didn't actually walk it, but about that, give or take, from the house. But the limbs actually were overhanging the driveway and part of the roof. The other one was a little further out, and it was not in quite as bad a condition, but it was already in early stages of death. So at the time, I was just like, okay, I have somebody coming, they're gonna cut the trees, just let them just get both trees. So I don't have to call them back next year type of thing. And then with the pine, that one was at the back of my house. And once again, it was closer to the house, probably 10 feet or less. And it swayed. Like anytime we had any kind of even little wind, it swayed, and it literally is like right over my daughter's bedroom. And so I just really felt that tree just needed to come down. And that's why I wanted to make the decisions on there. I do see that I'm in violation of some codes. I did, do effort. I made real effort to assist in finding the tree company person. I couldn't get an address, but I do have a phone number that was still working within 2 weeks. So, he still has a phone number out there that's in use. And I wanted to see if I could get some leniency. This was yes, ma'am. I think the thing about the damage on the car, I think it's only the page 3 or 4, but it shows like it had to be tree sap and things removed. It actually states that on the receipt for the damage to my car. And, you know, I was trying to follow the right steps. I did go through a tree company to have the tree removed. But being a little newer, and this is the first house I'm owning in Florida, I was just not aware to look for that with a tree company. So I'm asking for leniency. 57 inches is a lot, especially when 2 of the 3 trees were actively, one was pretty much dead and the other one was still actively dying also. And I just wanted to see if I could get reduced. I think the fine on this was $3,700 to $3,800, which was not quite as much, but really close to what it cut to cut down the trees. And I truly just don't have. I used my savings to get the trees cut down in the first place. And then I had damage to my car and I had to, you know, get my car fixed. I had, you know, rental. So I really just right now, I don't have $3,700, $3,800. You know, I'm like a nurse. I don't just make, you know, G-gabs of money. That was like my savings I used to have the trees cut down. So I was asking if I could get some leniency from the magistrate in court today on the $3,700 fine.
Okay. Well, obviously, your case got heard on the right day. You've heard all the previous cases to this point, which is the benefit for you being last. So I don't have any problem with reducing some of the DBH inches because you got a hold of a tree company who gave you a card, but really seems to be a little sketchier than most, unfortunately. So I'm okay with making that kind of adjustment. Obviously, you're aware of what needs to be done in the future. So just because they're driving around and knocking on your door doesn't necessarily mean that that's the right course of action for them to do. And now you know you need a permit. So I feel like there's some education here that's going to go a long way as well. So I'm okay with making an adjustment to that. In regards to the fund, is it your intention to replant some of the trees on your property to offset that, especially while they have this 2-for-1 inches going on right now special, or are you going to?
Probably I could replant a couple. I do have a larger lot, but you know, it was 57 inches. I didn't know about the 2-for-1, but we're talking 57 inches at 1 inch a piece. That's like, I can't plant 57 trees on my yard.
No, I understand that. Now you've heard the testimony. I guess I'll regurgitate it. But
yes.
You know, you can put it anywhere on your lot, and I don't, you know, you don't need to have a tree farm necessarily. You can do larger diameter trees, and you can also donate and to other organizations if you want to buy the trees instead of paying the per inch penalty. So there's a mix there that you can do to help reduce that liability as well.
I could do some, but I still don't, because even if it's 2-for-1 at 57, that's somewhere around like 26 to 27 inches of trees, which is still a lot of tree.
Understand.
But
My ruling is going to be for 48 DBH inches. So and that really comes down to 24. So that should help you significantly if you take care of it during the time frame for which this order is out. Because like I said, they're giving a 2-for-1 special right now. So that's pretty great to help out folks.
And could I have an extension? Because truthfully, I can't come up with $3,700 in 60 days. That's why I didn't pay it so far. It was a really large fine for tree removal.
You want me to go back to the original fine and just give you more days?
No, I can get some inches or whatever, but I just wanted to see if I could either have the original fine decreased or if I could have additional days.
So you want a decrease in the inches and additional days?
Yes.
Okay. As long as we're clear.
Yes, sir.
And let me clarify, you said 48 inches will be your reduction. That will reduce the restoration cost to $3,120. It was $3,700 earlier.
Okay.
So that will give you about a $600 reduction.
Do you have any concern with the extension in time based on location and?
No, sir.
Okay. All right. Okay. Well, I'll give you some more time too. Okay. All right. Thank you very much for coming down. I appreciate it.
Thank you.
I rule in case L217057 that based on the evidence presented, I find that the property is in violation of Hillsborough County Codes and Ordinances listed in staff's presentation. Further, based on the gravity of the violation, the action taken by the violator and the violator's history, I concur with staff's recommendations and require the homeowner to plant or donate 48 DBH inches of approved shade restoration trees or contribute 48 inches to the restoration fund within 90 calendar days. Trees must be 1 inch DBH or larger, minimum of 8 feet in height, Florida grade 1, chosen from the Hillsborough County approved tree list as appropriate. Contribution to the fund equates to $65 per DBH inch. Property owner Raina Roshan will be responsible for this violation. Failure to meet timelines listed above will result in a penalty of $250 per day. Thank you very much, ma'am. Have a nice day. Next case, please.
Okay, we don't have any other people
Okay.
to speak, so turn back to page 4. I didn't.
We still have Osmani.
We still have one case online.
Okay. Hold on, let me.
She's case number L216957.
Sorry, I didn't know they
Excellent.
were on. Okay, page 7, number 15, case number L216957. The owner is O&Y Princess Trucking Incorporated, location 5712 Bridle Path Lane. We have service and we have someone online. And is with the person online?
Osmani, can you hear us?
Yes, we can.
Yes, sir.
Okay, raise your right hand, please, to take the oath of witness. Can't tell, it is so tiny. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
And state your name and address.
Tu nombre y tu dirección.
Osmani Pompa
En 35.
in 3538 17th Avenue North, San Petersburg, Florida, zip code 33713.
Thank you. Are you representing O&Y Princess Trucking?
Yes, I'm the owner.
He is the owner.
Okay, thank you.
I think the young lady raised her hand as well. Can she give her information too, just in case she testifies?
My name is Sarah Proenza, and I'm acting as a translator for Osmani Pampa.
Excellent. Thank you for your service. Ms. Hall?
Yes, this is case L 216957.
Wayne Dorian, Hillsborough County Natural Resources, L216957, owner violator, O&Y Princess Trucking, Inc. Violation address 5712 Bridle Path Lane, Tampa, Florida. Violation, unpermitted disposal of fill material, dirt and rock millings within a 100-year floodplain area. Ordinance violated section 4.01, first inspection, June 21st, 2021. First notice, June 22nd, 2021. Last inspection, January 24th, 2022. Inspections conducted 4. This is a FEMA flood zone map of the area. The property in question, the black's outline, is approximately where the fill is located on the property. On June 21st, 2021, I responded to a complaint that the parcel has unpermitted storage of fill in the FEMA flood zone. Here's another picture of unpermitted rock millings in the FEMA flood zone. And on January 24th, 2022, a reinspection, unpermitted fill rock millings remain in the FEMA flood zone. This is from the back of the property, the back road of the property. This case came to light. They purchased this property, and as soon as they purchased it, they do own 2 other properties adjacent to it off of Van Ballad. They stored this material, and it is a FEMA flood zone, so no fill can be stored on a property without proper zoning and without permits. Staff recommendation: submit a compliant natural resource permit application to address the disposed fill material and stormwater requirements for the commercial property within 60 to 90 calendar days. The following items must be included in the application: submit a professional engineering plan or a certified floodplain manager report, provide an as-built plan of the final grade elevations, obtain and finalize a natural resource permit after receipt of application within 180 calendar days, or remove all fill material within 60 calendar days. Fines will be applied for failure to meet these timeframes.
Oh, okay, sir. What would you like to tell me?
If it's okay, since I've been filled in on all of this, I'd like to go ahead and speak on his behalf. First of all, okay, so there's a total of 4 lots that are owned here. 7706 and Ballard, and what backs this property up to is to 5712 Bridle Path. We are in the process of doing a site development plan. We just got on January the 4th, lot 7706 rezoned to M. We did in December the wetlands lineations. And you can ask Ms. Hall when we had the same issue on 7706, and you can see it in one of these photos. We put barriers. Last week on Wednesday, I don't remember, I don't recall which department came out, but they're always checking those wetlands. We have never contaminated or disposed anything on the wetlands. We're quite away. I understand that all of these, steps that this gentleman just went over are going to be done. We've hired a company, and we are trying to, as quickly as we can, working along with the county, meet all the requirements. I will also tell you that that little cul-de-sac on the Bridle Path area, we have been complimented several times because that was being used for a lot of illegal dumping. And ever since we bought the property and we've cleaned it up, I have text messages where they're telling us, hey, you're doing such a great job that you're not allowing anybody to just dump stuff and damage those wetlands. So all we would like, if all possible, is for you to give us the necessary time so we can finish and comply with the rules and regulations.
So it's your testimony that you understand that you're in violation and that the timelines and steps listed here are all the things that you're planning on doing, and you're okay with those timelines?
Well, this is a business, so we have to make it happen, sir. That's why we hired a professional company to help us, go along this entire process. I am not saying that we're not at fault. We actually were not aware, but we're doing the best we can to comply and make sure that we're within the guidelines of the law.
Okay. And it was also your testimony that you had another lot adjacent to this one that you
Yes.
went through the process with and rezoned. So actually you technically you knew that this parcel was going to have the same issue, correct?
Yes, but we just
But you
learned
went
that.
ahead and moved forward with it anyway.
Pardon me?
But you went ahead and added the fill anyway.
If I had to take it out, I'll take it out.
Yeah.
But
So it sounds like you might not need the translator anymore. It's very frustrating to me to see this case, to be honest with you. I mean, you have an adjacent property that had the same issue. You've gone through the process. You got it rezoned to M. You knew the process, but yet you bought another lot and you just went ahead and added the fill to it, just saying, well, I'm going to ask for forgiveness. I don't understand that. You knew the process from the beginning.
We're not asking
Excuse me, ma'am. Excuse me, ma'am. I'll be happy to give you time to speak. I'm just clarifying that the staff's recommendations here listed on this list are all things that you understand need to take place and the timelines for which they need to take place. Is that correct?
Okay, why don't we go step by step so you can tell me exactly what you're saying. As I'm reading here, it says submit. I can't even read it because I have something. Hold on. Okay, so we need to submit a permit, correct?
Right,
Or-
you need to have a natural resource permit that can either be a commercial permit or it could be a other permit. But this situation sounds like a commercial activity, so you're going to need a commercial permit. But it's called a natural resource. Now, I need to understand, did you get the correct zoning for this lot at this time?
It is zoned M. That lot is zoned M.
Okay, so and you've hired a developer or an engineer to help you with this project?
Yes, and I believe that your department sent a lady out that marked all the trees. Then we just did the new surveys for the lineation of the wetlands.
Okay, well, that was done by the Environmental Protection Commission. And you'll have to do the survey and get their approval of that survey before you submit it with the permit application. So what I need to understand at this point, since you are proceeding with a permit application, our recommendation says 60 to 90 days. We were debating on what was happening out there. So can you tell me if your project manager can submit this application within that time frame?
I believe that it has been submitted because the surveys were done and they were submitted to the department waiting on the approval of the surveys.
Okay, that is not a permit application. That is a wetland survey. The permit application is the next step after you get the approval of your survey.
From what I understand, we're waiting on the approval. Soon as that approval comes in, which should happen now in February, we are submitting the application.
Okay, so the time frame of 60 days, they should be able to meet.
Yes.
Okay, that's what we needed to know, ma'am.
Okay.
Mr. Dwight, how much fill is out there at the site? What are we talking about as far as?
Oh my God. Last time I was out there, probably 50 feet by 200 feet. That would be my guess.
Okay.
I got a lot left. I got a lot left right now.
You have what?
It still coincides what you had marked on the map, Wayne?
Yes.
Okay.
Size of the fill is the black outline shown on the parcel?
Yes, that's estimate. Yes, sir.
Okay.
But it's not that big anymore and it's a lot lower.
Well, that's good. We're heading the right way.
I keep it almost like a half of that.
Okay.
Yeah, it's about half of it.
Okay. All right. Mr. Osmani, do you want anything else you'd like to add to your testimony before I make a ruling?
No, sir. I appreciate if you give me some time.
Yep. I think the timelines are listed in staff's recommendation. I'll review them as part of my motion.
Thank you, sir.
Absolutely. I rule in case L216957 that based on the evidence presented, I find the property is in violation of Hillsborough County codes or ordinances listed in staff's presentation. Further, based on the gravity of the violation, the actions taken by the violator and the violator's history, I concur with staff's recommendations require the landowner to submit a compliant natural resources permit application to address disposed fill materials and stormwater requirements for the commercial property within 60 calendar days. The following items must be included in the application. 1, submit a professional engineer's plan or a certified floodplain manager reports and provide an as-built plan of the final grade elevations. Landowner will also obtain and finalize the natural resources permit after receipt of application within 180 calendar days, or remove all fill materials within 60 calendar days. Failure to meet any of the timelines listed above will result in a daily fine of $500 per day. All right, folks, you have your timelines and you understand the process and you're waiting for approval. So just keep an eye on those timelines as you move forward and stay in touch with the folks in natural resources so that you can make sure you remain compliant as you go through the process.
All right.
Thank you, sir.
Thank you,
Thank
sir.
you very much. Have a great day.
You too.
Bye-bye.
I believe that's all the people.
Okay. Seeing that no one is present in the audience for the remaining cases on the agenda, I will now review the case materials previously provided by county staff. And if I find the property is in violation of Hillsborough County codes or ordinances as listed in staff's presentation, my ruling in each case will be based on the evidence presented, the gravity of the violation, the actions taken by the violator, and the violator's history in determining the amount of fine that will be assessed. Next case, please.
Page 4, number 9, case number L216662. The owner is South 58th LLC. Location 2426 South 58th Street. We have service and no one is present.
Krista Hall with the Development Services Department, case L 216662. The property owner and violator is South 58th Street LLC. Violation address 2426 South 58th Street, Tampa. Violation, unpermitted disposal of fill materials located within a 100-year floodplain area. Ordinance violated, section 4.01.03, first inspection, February 23rd, 2021. First notice, March 4th, 2021. Last inspection, January 26th, 2022. 3 inspections conducted. The FEMA flood zone map shows the property has fill materials located. There was also a new map that was brought to our attention, and that is an up-to-date and current map. FEMA maps aren't updated for several years, but the county map is, and that one shows that most of the property is in a flood zone. The inspection was conducted by Tony Hood on February 23rd, 2021, noting the storage of fill materials on the property within the FEMA flood zone. There was a reduction of the materials, but it still was located in the flood zone noted on October the 27th. This inspection was conducted by Wayne Doyne on January 26, 2022. Fill materials remain on the property within the flood zone. I will note that I have talked to the property owner and explained to him about the county flood map, and that his removing the fill out of the flood zone had to meet the county flood map and not just the FEMA flood map. So the county's recommendation for case L 216662 is the property owner to submit a compliant natural resources permit application to address the disposed fill materials and stormwater requirements for the property within 30 calendar days. The following items must be included in the application: submit a professional engineer's plan or certified floodplain manager's report, provide an as-built plan of the final grade elevations, obtain and finalize the natural resource permit after receipt of application within 90 calendar days. Fines will be applied for failure to meet these timeframes. After speaking with the property owner, he has agreed with those timeframes, and he is proceeding with some renovations where he needs to fill. And so that's why he's not here today.
Okay, so you guys have a plan. Terrific. I concur with staff's recommendations in case L 216662 that the homeowner will submit a compliant natural resources permit application to address the disposed fill materials and stormwater requirements for the property within 30 calendar days. Following items must be included in the application: submit a professional engineer's plan or a certified floodplain manager's report, provide an as-built plan of the final grade elevations, obtain and finalize natural resources permit after receipt of application within 90 calendar days. I don't see an opportunity for this homeowner to remove the fill if they're doing something with the.
He said he removed what he could, but he needed to use the rest. And I said, since your whole property's in the floodplain, you're going to have a permit.
Okay. All right. So there's no option for him to remove all of the.
I mean, if you want to go ahead and add it.
I think I will. I think
Okay.
I'll also add or remove all of the fill material within 60 calendar days.
Okay, I would match that with the first one though, so that if
Within
they-
30?
Yeah.
Okay, let me start over. We'll just do that from the top. I recommend in case L 216662 that the homeowner submit a compliant natural resource permit application to address disposed fill materials and stormwater requirements for the property within 30 calendar days. Following items must be included in the application: submit a professional engineer's plan or certified floodplain manager's report, provide an as-built of the plan of the final grade elevations, obtain and finalize natural resource permit after receipt of application within 90 calendar days, or remove all fill materials within 30 calendar days. Failure to meet any of the timelines listed above will result in a penalty of $250 per calendar day. Thank you. Next case, please.
Page 5, number 10, case number L216726. The owner is Renee E. Rivera, and the violator is Mr. Lopez, DBA Lopez Landscaping. Location 10533 Opus Drive. We have service on both parties, and no one is present.
This is case L 216726. Property owner and violator is Renee Rivera. The violator is Lopez, doing business as Lopez Landscaping. Violation address 10533 Opus Drive in Riverview, Florida. Violation observed is improper pruning resulting in the effective removal of the street trees. Ordinance violated is section 6.0605. First inspection, March 10th, 2021. First notice, April 5th, 2021. Last inspection, November 30th, 2021. 2 inspections conducted. John Beavers conducted the effective tree removal on March 10th, 2021. On November 30th, 2021, the tree has epicormal sprouts, but it's still in effective removal state. The property owner and violator is required to replace the street trees in 30 calendar days. Trees must be 1 inch DBH or larger, 6 feet in height, minimum, or Florida grade number 1, chosen from the Hillsborough County approved street tree list. Palm trees must be 8 feet in trunk height at a ratio of 2 to 1. The violator, Lopez Landscaping, shall be responsible for restoring the street trees. Fines will be issued for failure to meet timeframes.
Any communication with the violator?
All I was able to get was that Lopez called and confirmed that he got the hearing notice.
Okay. I rule in case L216726 that I concur with staff's recommendations require the violator replace the required street tree within 30 calendar days. Trees must be 1 inch DBH or larger, 6 feet in height minimum, and Florida grade 1, chosen from Hillsborough County approved street tree list. Palm trees must be 8 feet in height and trunk height and at a ratio of 2 to 1. Violator Lopez Landscaping shall be responsible for restoring the street trees. Failure to meet the timelines listed above result in a penalty of $150 per calendar day.
I would like to add that we include the property owner. In this situation, it's a street tree, and if Lopez fails to meet that requirement, the property owner is still going to be obligated to meet it. So I'm going to have to include them.
Was the owner properly noticed? Okay. And then I'm happy to amend my recommendation to include the owner being responsible for the street tree as well, Ms. Renee Riviera. Next case, please.
Number 11, L216839. This case was pulled for staff. Page 6, number 12, case number L216851. This case complied on January 28, 2022. Page 8, number 16, case number L216980. This case complied January 31st, 2022. And that concludes the agenda.
Thank you, everyone, for helping out. That's online today. Appreciate it. This meeting is adjourned.